Well, good morning, everyone. It is my pleasure as Vice President of the CAM-CCBC to welcome everybody to the launch of the Oil and Gas Committee with this event this morning. Uh, this is a project that we've been working on for about a year after the launch of the Rio de Janeiro office of CAM-CCBC last year. Unfortunately, 2020 has been a very challenging year for reasons everybody knows. And at least now we have hope that next year maybe we'll be able to get together again and have live events with the presence of everyone and not only webinars. Nevertheless, we decided to have this launch anyway because we can't wait forever. So this is it. We're going to have a very lively and interesting discussions on institutional and ad hoc arbitrations, on contractual networks, and a keynote speech by Tim Martin on joint operating agreements. I'd like to thank our president, Leonora Coelho, and all the staff of CAM-CCBC for the continuous support and the fantastic work that they do. We hope that this Oil and Gas Committee will be a place for future discussions and debates. Oil and gas is a major user of arbitration worldwide and also in Brazil. So this is a project that we hope to engage all practitioners and have fruitful discussions on the issues that matter to the industry and to arbitration and mediation. We at CAM-CCBC, we don't charge for our webinars, but we do encourage our attendees to make donations to charitable institutions or NGOs that do social work. Today, we'd like to share you an important social project that we support, the Grota String Orchestra. The orchestra is a project developed by the Grota Cultural Center, an NGO based at the Grota Favela in the outskirts of Niterói. They have won many awards for bringing culture and education to marginalized Rio communities and were deemed to be an immaterial heritage of the state of Rio. To those who are interested, the donation links and bank accounts are available at the Zoom chat. Well, I'm here just to open up the event. So I'll pass on the floor to Gustavo Fernandes, who will moderate the first panel. Good morning, everyone. I hope you enjoyed this event.
Good morning, everyone. Thank you, Rodrigo, for the introduction. For me, it's a pleasure here today for two reasons. First, for the initiative of the CAM-CCBC to open up a committee on the subject matter of oil and gas industry. As a lawyer based in Rio de Janeiro and involved in the industry, it's very good to see this initiative that is so important to our city, to our business. So first of all, I'd like to congratulate the CCBC for this initiative. And second is the event itself. We're going to have a great event here. We have outstanding experts from Brazil and abroad. They'll be giving us all the details, all the updates on this very highly sophisticated industry, which is the industry of oil and gas. And as you know, it is facing tremendous challenges this year, and that's what we should hope for the coming months. The topic of our panel is institutional versus ad hoc arbitration. As we know, the oil and gas industry has made use of both forms of dispute form settlements. We all are familiarized with the oil and gas disputes of the 1950s and 60s and 70s, which have made I could say, the groundwork for international arbitration as a whole. But of course, many arbitral institutions have played a very important role on this area. And here, Brazil, CAM-CCBC has also played a very important role in this area as well. Well, we all know the main differences between ad hoc and institutional arbitrations. We know how good ad hoc arbitrations can go, but we also know that some things can go wrong. So it's very important to have well-drafted arbitration clauses when the ad hoc arbitration form is the preferred one. But of course, we understand that each day more, institutional arbitration has played a major role in assessing and assisting the parties in reaching their final decision-making, and as is the case with the CCBC. So here we will start directly with the topics, and I'll pass to Danielle that will be making the first topic here today. Danielle, the floor is yours.
Thank you, Gustavo. Can I just briefly thank you and CAM-CCBC for the kind invitation to be part of the launch of this oil and gas committee. It's a pleasure and an honor for me being here. The first topic I think we could start discussing is, we all know that an institutional arbitration per definition involves an arbitral institution. And one could discuss what would be the relevance, if any, of the seat of the arbitral institution. I'm not saying the seat of the arbitral tribunal, I'm saying the seat of the arbitral institution itself. And more specifically, what will be the relevance, if any, to the nationality of the award? So for example, CAM-CCBC has its seat in São Paulo and a very nice office in Rio de Janeiro. Does it mean that every CAM-CCBC arbitration award will be a domestic one? Conversely, does it mean that the DIS, the Deutsche Institution für Schiedsgerichtsbarkeit, that has its seat in Berlin and also a very nice office in Bonn, does it mean that any DIS arbitral award will be a foreign one in Brazil because the DIS has its seat in Germany? The nationality of an award and whether it is a domestic or foreign one has many legal consequences and practical consequences. So just to give you one of them, if we have a foreign arbitral award, it means that before the prevailing party can enforce it in Brazil, it must previously have it recognized by the Superior Court of Justice, something that can take a while and cost a lot of money. And I would like to give you an example, a practical example of this problem. The Superior Court of Justice, the STJ, has judged a very interesting case, and that's the Recurso Especial 1231554. And all the facts are public. The case concerned an ICC arbitration involving a dispute between a contractor and a subcontractor for the P36 platform. And the arbitration agreement provided for a sole arbitrator, and in the case, it was Justice Francisco Rezec, and the arbitration has its seat in Rio de Janeiro. The claimant prevailed, and soon after the award was rendered, it started enforcement in Rio de Janeiro. Respondent then objected to the enforcement, alleging that that was not a domestic award, but rather a foreign award. After all, it was rendered, and I quote, by the International Court of Arbitration, which has its seat in Paris. So this ICC award would, according to respondent, be a foreign award and will thus need to be first recognized by the Superior Court of Justice. The first instance judge disagreed, and we'll see that I think it's quite correctly, and ruled that this was a domestic award. But then the Court of Appeal of Rio de Janeiro reversed, saying that because the award was issued by the International Court of Arbitration, which has its seat in Paris, this would be a foreign award, and before enforcement, it should have been recognized by the Superior Court of Justice. Then the case reached the Superior Court of Justice, which reversed again the decision of the Court of Appeal and reinstated the decision of the first court judge, deciding basically that the place where the arbitral institution has its seat is legally relevant for the characterization of an award as domestic or foreign. And what can we make of this decision? I think that this is a very interesting case, but the solution, at least in my opinion, was quite straightforward, at least in that case, because Article 34 of the Brazilian Arbitration Act provides that an award is foreign as long as it has been rendered outside Brazil, meaning conversely that if an award is rendered in Brazil, it will be a domestic award. I think that what this case also shows is that sometimes, and at least for the layman, the layperson, there can be some confusion between an arbitral tribunal and the seat of the arbitral tribunal in one hand, and the seat of the arbitral institution on the other hand. We all know that the arbitral institution is not an arbitral tribunal, but I suspect that at least for the layperson or at least for those who are not very familiarized with arbitration, the names of certain arbitral institutions, for example, the LCIA or the ICC, it may help creating this kind of confusion because they all include the name court in the name of the chamber. But I think that after this decision from the Superior Court of Justice and the wording of Article 34 of the Brazilian Arbitration Act, we can conclude that what is relevant is not the seat of the arbitral institution, but rather where the award was rendered. I think that's what I think we could maybe start a conversation on that. I have many further comments, but I don't want to hijack the panel. Maybe Gustavo and Gloria may want to comment on that, or?
Sure. I'll pass the floor to Gloria so that she can also add her views on this very same issue.
Thank you very much. Of course, gratitude is due, and I have to say thank you again to CCBC, to CAM-CCBC. I have always felt more at home at Brazil and with Brazilians than in Mexico with Mexicans somehow. And I just want to congratulate all of you and obviously this very interesting initiative that hopefully is going to be very dynamic and it can really be very productive for all of us as academics, experts, and practitioners working in this very complex, fascinating, but everyday very challenging industry like the oil and gas industry. So I just want to say something before I forget, Daniel, from your intervention. While you were talking, I could not stop thinking, what was the role of the New York Convention in the interpretation of all this dialogue? Because, okay, it's important, names are important, but at the end of the day, we already have a very clear instrument that somehow, and hopefully, it saves us some time of this kind of discussions, where the award is coming from, is it international or not. So I wonder if you could perhaps later on tell us a little bit more, or if there was any mentioning at all to the New York Convention. My intervention is just a little bit perhaps within the framework of this discussion, what is more important, the seat or the place where you eventually are going to enforce the arbitration award. This is very important, of course, when we choose either to have an ad hoc arbitration or an institutional arbitration, but I think it's also almost a cynical question. What is more important, the seat or where you're going to enforce it? And different people have different answers. I personally think that it's more important, where do you enforce the arbitration award? But I have heard, at least from the Mexican community, that it's important than the seat, that you have a seat that kind of nurtures the arbitration process and the applicable law to that arbitration process, so that eventually the award is strong anywhere in the world. That's a very important discussion. Within that discussion, I always like to talk about the differences between the seat, or the importance of the seat or not, with a very famous case that you probably all know, which is Egypt versus Chromalloy. This is one of the very first cases where the District Court of Columbia became very famous. And until today, the District Court of Columbia always has very forward-looking arbitration awards that we all learn about, like Mitsubishi versus Soler, and more recently, a lot of the arbitration awards against the Kingdom of Spain have eventually landed in this American court. But the important thing about Egypt versus Chromalloy is that, for example, in this case, although it's not an oil and gas case, it was a contract between Chromalloy and the Egyptian Arab Force for the providing for parts, maintenance, and repairment of helicopters. And when the dispute started, obviously, the government of Egypt said, okay, there are many things here of public policy. This cannot go to arbitration. Eventually, they had an arbitration award that was challenged in Egyptian courts because of public policy issues. But Chromalloy took the arbitration award to the US. And in the US enforced the arbitration award because eventually they say, well, what is important, it is not the seat, but where you enforce it. And here we are going to enforce the arbitration award. And I always find very fascinated, albeit a bit old, Egypt versus Chromalloy really shows you that might be not that important. And that takes me to another very interesting point, that although it started in academia, it has a lot of relevance in practice, which is the localized theory. And essentially, the localized theory was initially created to destroy all these tensions, so that the arbitration process is not attached to any domestic court. And we know that very well from France, for example, because in France, and Daniel, as you well known, Gustavo, in France, if the arbitration award is a domestic award, there are some rules about, or at least some possibilities to challenge that arbitration award, or at least to seek some sort of review. But if the arbitration award is international, then it's almost untouchable for French courts. And that is very interesting, or at least it really is emblematic in the sense of this is really what the localized theory means. Of course, that has kind of transpired all the way to London. And of course, that's the reason English courts are so popular, to seek recognition and enforcement of arbitration awards. One of the very important and most relevant cases in our region in Latin America, as we know, is Occidental versus Ecuador, where really had nothing to do with London, but the seat was London. And many of the reasons, if you read the arbitration award, is because parties really wanted to have a neutral seat. And eventually they wanted to enforce the award there. So it kind of also gives legal certainty, if you want, to sometimes very problematic type of disputes, or where there is a political or public policy connotation in there. And I have many other issues to touch upon on the delocalization theory, but maybe emphasize that the localization theory started also with Frederick Eisman, who probably that he was at some point the president of the ICC court, but he did not propose that in his role of the ICC court. He was a very active member when the UNCITRAL model law was being negotiated and created. And he really was the one who put forward that arbitration should be a national. And that is something that we all know we can find in the UNCITRAL model law. And obviously that kind of had its legacy in the ICC rules. As we know, the ICC rules say, well, there is no seat, and if they did not choose the seat, there are other mechanisms where the seat will be chosen, which is what I will say is the more kind of autonomous type of arbitration rules. There are other more strict type of rules, like the LCIA. Say, well, the seat is London, and they don't give you that freedom of that room for discussion if you fail at including that at the arbitration clause. And very interesting, I think there's a third type of arbitration rules, like the CAM-CCBC rules, that it gives you guidance, but it does not impose on you a specific seat. So they say, if I am correct, it can be seated in Brazil or anywhere, and otherwise the tribunal will decide. So there are different spectrums of facilitation of the seat across different arbitration rules, which I think is important to consider when we are thinking either institutional, ad hoc within our oil and gas industry.
Okay, let me now start to put some hard questions for our panelists, okay? So let me start with reference to Brazilian law, okay? Because you also have other jurisdictions that follow pretty much the same system, which is the Brazilian Arbitration Act does not make any reference to the seat. There's no, the seat has no legal relevance for an arbitration in Brazil. This is the first point. And that's, for example, our code of civil procedure. Whenever you need to determine the jurisdiction of a specific court for annulment, the seat is not taken into consideration. Either the contract has a forum choice clause, or you're going to have to follow the rules that are in the code. So the seat is not relevant for the arbitration in Brazil. Even if the party chooses one in the contract, it doesn't have relevance for the jurisdiction of the courts. This is the first point. And the second point is Brazilian law, also like other systems, doesn't have a different treatment for international or national arbitration. It's either a domestic award, and therefore it'll be subject to enforcement according to Brazilian law, procedural law, or you have a foreign award that you have to go to obtain exequatur before it gets enforced here in Brazil. So, so the point is, in the systems where the seat is not relevant, because simply the arbitration law doesn't give any substantive meaning, at least expressly. Maybe the scholars will give, but the law itself doesn't do. Do the courts need to look to what really happened in terms of the substance where the proceedings had their place, or, for example, where the award, as it is the case in Brazil, where the award is issued? But then we have, well, now that you have a sort of a virtual hearings and arbitrators everywhere in the globe, where is the award? Where is it? So how a system like the Brazilian one can be consistent, where each day more what we see is that there's not a place, really, a single place where the award is drafted. How do you react to that? I'll start with Daniel.
Maybe that would be the perfect time for my internet connection to fail, because this is a very, very difficult question. I might just pretend that it freezed, and hopefully you'll give up waiting for me. But I think, Gustavo, I understand that the seat might not be as relevant as other elements of the arbitration for the Brazilian Arbitration Act. I'm just not that convinced that it's completely irrelevant for any purpose. But that's not the point here. I think that the Brazilian Arbitration Act only requires the award to state the place where it was rendered, and that's Article 26 of the Arbitration Act, where the award was rendered. And then we can discuss what does it mean? Where is an award rendered? And then I think we have maybe three different theories or arguments one can make. The first one is that the award is rendered where it was physically rendered, where it was drafted and signed. I'm not saying that's the correct solution, but I think it's arguable that that's where the award was rendered. That's where the award was actually drafted and signed. If we follow that first argument, we might face problems like you've just identified. Where is an award drafted and signed, especially now that we are all communicating through the internet. But I think that this first argument, this would not be a problem if all the arbitrators were Brazilian, they were all living in Brazil, and the arbitration was conducted in Brazil. So I think that I'm not saying I'm not saying that this is the only possible solution, but I think that this solution is not a problem if all the other elements of the case are connected to Brazil. But I think that one could interpret Article 26 in a different way. Maybe saying that the award is rendered in the place of arbitration, even if this is just a legally and fictional element. So one can argue that the arbitration award is rendered at the place of arbitration. And I think that the third and last possible argument in theory that you could have is that the award is rendered where the arbitral tribunal says it has been rendered, irrespective of whether it is the actual place where it was drafted or whether it is the place of arbitration. But at the end of the day, and that's, I think that just to conclude my answer, I think that the difference between those three theories or line of reasonings won't make much of a difference if you have a simple case in which all the arbitrators are Brazilian, the award was drafted in Brazil, all the hearings parties and their counsel were in Brazil. So I think that the difference between those three theories maybe would only be relevant in practice if you have a difficult case where there are more foreign elements than simple case where all other elements are connected to Brazil.
Okay. Gloria?
Well, no, I agree with everything Daniel has said. I just think maybe in the oil and gas industry, sometimes that's a little bit more complex. For example, in my experience, I have worked in cases where everything, literally everything happened in Mexico. Even the arbitrators are Mexican, but somehow the contract has English applicable law. And that kind of transfers or has another new dimension where if the arbitrators neglected to somewhere say where is the seat or where is the place of arbitration, I don't know what I will do, to be very honest, if I were a Mexican judge, if I see that and I don't know where the award comes from. I know what Daniel said, that there are different tests, different standards, but maybe I will give a very simplistic rule, but I learned it in my first case as an arbitral secretary. You always write the seat of arbitration when you write your award. It's one of the very first things you draft when you draft the award. And it might be very, very simple what I'm saying, but I think it's of utmost importance. And it comes to the heart of one of our points of discussion today about choosing the right arbitrator. And I'm very sorry, but my simple question, perhaps it's just pragmatical, but it's the truth.
Okay, still on the topic of the seat, let me just hand you another easy one, which is, as Gloria has already mentioned, where you have the court at the seats annulling or setting aside the arbitral award, and then and nevertheless the arbitral award is taken to another jurisdiction for enforcement. French law is quite clear on the point. For the French courts, what happened at the seat remains in the seat, so they don't look at what happened there to decide how the award will be enforced. But for example, if you look to the US courts, sometimes they deny enforcement if the award has been annulled at the seat, and sometimes they decide to enforce it. So it's on a case-by-case basis. But the question for you is a different one. if it seems, even from the French law, which is, I think, I don't know if it addressed this very, very specifically, but if to the same court, if both the arbitral award and the court annulling the award, if both decisions are submitted to enforcement, it seems that arbitral awards tend to have some preference in being enforced according to NY law. But is this a correct approach? Because if the same court at the enforcement stage receives the arbitral award and the court decision setting aside that very same award, it seems to be a more complex problem. Any indications on how that could be solved? Because I remember that I think it was in the Cromaloy case, the solution that the French court took was that because the arbitral award had been submitted first, therefore they could not enforce the court decision. So it was a sort of a decision based on the timing of the submission. But is this the right approach? Or, for example, does the committee principle should have a role? I know it's a very big question. That's a very broad one, but I would like to have your views on that. Daniel, please.
Okay, I'll go first. And I have a very strong opinion on that. I've written about this subject since 2009.
I know.
Maybe I should just clarify before answering your question. I think we should take a step back.
Sure.
I don't believe that arbitral awards are like walking deads that after they've been killed, they could still have legal consequences because it wants. What French law has done is based on Article 7 of the New York Convention. So it's not based on utopical literature. It's just because the Article 7 of the New York Convention allows domestic law to provide a more favorable regime for the recognition of arbitral awards. And the code, and the French Code of Civil Procedure does not provide that the fact that the award has been annulled in the seat is a barrier for its recognition in France. So this is a very technical and correct solution. It has nothing to do with the dreamy idea that arbitration has its place in the clouds and is a national. It's just a national solution. Whereas what happens in the United States is that courts have interpreted Article 5 of the New York Convention, and the word may be refused as granting the court some kind of discretion whether to recognize or not. This is debatable, but that's the solution that's the solution that the U.S. courts have followed. Now addressing and just one final thing that I think we should all remember: the award can be, for the purpose of the New York Convention, the award can be annulled either by the courts of the seat. And that what happens in 99% of the case. But I think we should all remember that Article 5 of the New York Convention also allows the courts of the country, the law of which was applicable to the procedure, also to annul the award. This is sometimes forgotten, but that's also possible. Now coming to your question, I think that. But that's my opinion. I understand that there are other different opinions. I think that if an arbitral award is annulled by the courts of the seat, the judgment that has annulled the award does not have to be recognized in the forum before we deny recognition to the arbitral award. I think that in this case, the judicial judgment that has annulled the arbitral award has just what in French they call effet de fait, and I think that in German, just to show that I speak a little bit of German, I think that they call Tatbestandswirkung. I don't know how to say that in English, but the point is that if an arbitral award has been annulled, you don't have, at least in my opinion, you don't have to first have the judicial judgment recognizing the forum before you deny recognition through the award. I know that French courts have said that if you have requested the recognition of the opt award beforehand, so this should prevail, but I don't think it is a matter of who has reached first the court, but rather whether or not you think that the annulment of the award by a court of the seat has any bearing on its recognition in the forum. And just to finish, I'd just like to remind us all that the Superior Court of Justice has already addressed this question. I think that the solution was correct. The Superior Court of Justice has denied recognition to an award that had been annulled in Argentina. But with all due respect, the reasoning, I think it was a bit clumsy and did not fully address all the questions that for the past 20 years we had been discussing.
Gloria.
To be honest, I think it's a very complex question because it will also depend on where do you land. So, you know, you can land in France, but you can also land in the US. And as Daniel just mentioned, you can land in one of our countries where I think a Brazilian judge or a Mexican judge will not feel that comfortable about enforcing an award that it was previously annulled somewhere else. And that it comes again back to the question of what is more important, the seat of the place of the enforcement. You need to have a good seat that follows all the rules, and so that you have an award that is pretty strong at its own home. I can only think about a great example of, I'm sure you all know it as well, Fincantieri versus Italy, and Fincantieri versus, Fincantieri versus Italy, and then this very Fincantieri arbitration award landed in two places, in Italy and in Switzerland. And it was first announced in Italy because of public policy issues. The key aspect there was a United Nations sanction about the selling of war weapons, if I'm correct, to Iraq. And then that very United Nations sanction was questioned when the award was sought enforcement in Switzerland. And in Swiss courts, the approach was completely different. They said, well, this is a United Nations issue, and this is for United Nations to resolve. But as far as the commercial contract and the commercial dispute relates, we are going to enforce the arbitration award. And yes, and it's what Daniel says, it's not about timing who was first, but rather the mindset, the cultural approach, the applicable law, and the understanding of the judges of, there are also two streams of public policy, the one that we look domestically, but the one that we have to look in, the one that we have to read arbitration awards, international arbitration awards. So I don't think there is one answer in this conversation. Maybe we can create a mini working group about this issue, but it's definitely one of the most interesting and very complex internationally.
Okay, before we move to our next topic, I would like to remind the attendees that we have a Q&A button, so all questions can be sent there, and then we submit that to our panelists, okay? All right, now we move to the topic of choosing the arbitrator. As we all know, you can only have a good arbitration if you have good arbitrators to decide, if you have the right people to read the case and come up with the right decision. So this is going to be our next topic, how to choose arbitrators for oil and gas dispute. Is there any specific method or criteria to apply? How this has been made in the past? I'll pass the floor now to Gloria.
Okay, what I have for this question is more of guiding principles, guiding ideas that I would like to put forward to all of you, and then you tell me whether if you agree or disagree. Sure. I think when you choose an arbitrator, particularly in the context of this panel, because we're talking either institutional or not, an arbitrator with experience for ad hoc arbitration, it's really, really, really important. You don't want an arbitrator that this really doesn't know how to manage the case if you are in an ad hoc arbitration, because it can be not only very expensive, but very lengthy. Finding meaningful information on the level of expertise of an arbitrator is not easy. Even if there are open databases, we truly tend to rely on personal inquiries. We all do that. But we have to remember that the selection is critical for the efficiency and legitimacy of the system. And as we were talking, we need to have a good arbitrator, because then that might impact the way our national courts read arbitration awards. So it really impacts the whole kind of impression of justice international arbitration is being assessed against too. There are also a lot of asymmetries. Sometimes it's hard to make a difference between somebody that has very good marketing and is a highly confident arbitrator against somebody that perhaps doesn't have, doesn't spend a lot of time on LinkedIn or doesn't have a very sophisticated website, but is generally a very experienced arbitrator and has a very solid background. So there is no straightforward. And so as practitioners, Gustavo, I'm sure that there is a lot of responsibility. And as English people say, you have to take it with a pinch of salt when you see one arbitrator against the other. But I do think that our community is always being challenged by the impression and by what an arbitrator seems to be offering, to rather what the arbitrator really has, in terms of under its belt, in terms of experience. In Latin America, there is an additional caveat when we think about choosing the right arbitrator. And then again, I'm sorry that I am too obsessed about it, but I see it quite a lot in my current cases, is that you need an arbitrator that understands the political changes, the public policy issues that are happening in our countries, but also that person can read those issues against the applicable law. So how do you understand frustration? How do you understand repudiation, in a Brazilian context, in a Mexican context against English law? Because obviously, as we know, for example, there are standards that are very high. But then when you see sometimes what some government authorities do, you might think, well, this looks like something that in English law, the threshold is quite high. So you need an arbitrator that understands what happens in that specific country with that specific state-owned company, if it's the case, while understanding a foreign applicable law. I think for me, that's one of the most important things. And it's very challenging to have an arbitrator with essentially two brains, but we must have that. For example, if we have a gas pricing dispute, it's important that the arbitrator understand that they might exercise their powers beyond the normal, beyond just applying the applicable law. And that means sometimes they have to use exequat bono, or they have to decide a gas price formula based on good faith. And that is very important. The arbitrator understand how is this gut feeling effect. And for that, you need an arbitrator that is not only confident, but understand this type of issues. There are some institutions that have already energy list of arbitrators. ICDR has one energy list of arbitrators, for example, and also one of the sister institutions of ITA, the Institute of Transnational Arbitration, has also an energy arbitrators database. What I did, just to kind of conclude these thoughts, I have 4 commandments when choosing an oil and gas arbitrator. First of all, you have to choose an arbitrator that has manageable caseload. Because I know, and it's very normal, I think, particularly in our own legal culture, sometimes we go for the big names, for the arbitrators who have a lot of expertise, but we need to balance that with somebody who can resolve the dispute, has time. So we need to prioritize. Obviously, we don't want a dispute to be resolved very fast if that arbitrator does not have the experience. But it's also important that, maybe a very popular energy arbitrator might be just too busy. And an energy arbitrator, I think, is a very general concept. It's different an arbitrator from oil and gas industry, from an arbitrator maybe that looks into marine law issues or, shipping services. against one that is only working on the renewables industry, so maybe has more understanding of competition law or regulatory issues or something of the like. Then I think it's important, I don't know what you guys think about it, but I think it's important to consider within this political context, consider the arbitrator's nationality. I see many times, and sometimes I don't understand why in big cases, in energy cases in Brazil or in Mexico, sometimes the president has nothing to do with the dispute. It's just a very respected person, but it doesn't really understand what happens in Brazil. It doesn't speak Portuguese. And sometimes I am a bit disappointed of the choices. Maybe it was not the choices of the lawyers, but what the institutions put them forward to them. And then you don't have a choice. I don't know, Daniel, Gustavo, what's your experience on that? But sometimes I'm shocked when I see some presidents. I get worried about how well they will understand the dispute. And I think lastly, but very importantly, I think an arbitrator has to have not only a good know-how, but has to have strong management skills. They have to really tailor-make the arbitration process to that specific dispute. For example, maybe that dispute is going to be too contentious, too lengthy on document production, and the arbitrator cannot have this general formula, this general procedural calendar for all their arbitration cases. I think an arbitrator needs to understand where the core issues are. Maybe it will take longer to work out the expert opinions. Maybe the on-site visits are very important. So I think it's important that the arbitrator has this, is also a good manager, not also a good lawyer, but really, really a good manager with time. And those are my ideas, initial ideas of what you should be thinking when choosing an oil and gas arbitrator.
Daniel, what are your views on the same topic?
Oh, I think that choosing an arbitrator is one of the most critical decisions a party and its counsel can make in an arbitral proceedings. And it has already been said, and I think I fully agree that it is an important, but it's an important choice not only for the parties themselves, but also for the reputation and standing of the arbitration process itself. So choosing a good arbitrator is a decision that has to do not only with the self-interest of the parties, obviously it has to do, but I think it has so to speak, an external consequences to the integrity of the arbitration as well. And to begin with, I agree with what Gloria said, but I think that I don't want to be cynical. I think that the ideal arbitrator, even if one could find the ideal arbitrator, probably would not be able to be chosen because they would neither be independent nor impartial. So it's the idea of having an ideal arbitrator is limited by the duty that the arbitrator has to be independent and impartial. And I think what Gloria has addressed very well some of the qualities that the arbitrator must have. I think I'd like to address two other qualities that sometimes I think are sometimes just too often and too quickly forgotten. The first one, and I'm not saying this is a cake recipe, I'm not saying it's one size fits all, it really depends on the case, but I think that in general, we should also try to find an arbitrator that has the ability to build consensus, because at the end of the day, a party can only, when it can only choose 1/3 of the arbitral tribunal. The other co-arbitrator will probably have been chosen by the other party, and the presiding arbitrator will have been chosen either by an institution or by the two co-arbitrators. So I think that we should be concerned in choosing, when we choose a co-arbitrator, especially one that has the ability to build consensus, because we make no mistake, the drafting of an award is sometimes a work of a bargain and between the members of the arbitral tribunal, and there's nothing wrong with that. I think that's one of the beauty of having a tribunal of 3 members. You have different views, and the arbitrator try to discuss and reach, when it's possible, consensus. So I think we should also pay attention to soft skills of the arbitrator, and I think that the ability of building consensus may sometimes be a very important one. The second thing that I would like to address is that normally, I think you will want an arbitrator that has experience in the industry or with the applicable law. But let me be a bit provocative. I think that sometimes it might be in the best interest of the party not to choose an arbitrator that has just too much experience in the industry and with the applicable law. Obviously, you should choose an arbitrator that is intelligent, but that sometimes you don't want an arbitrator that for the past 40 years has built strong convictions on certain aspects of the industry and of the law. Because sometimes, I'm not saying always, but sometimes you want to choose an arbitrator that is amenable and permeable to your arguments and maybe new theories. So choosing, when we say that you should choose an arbitrator that has a lot of experience, well, sometimes this is good, but sometimes I think we should take a step back and think, do the theories and arguments that we will submit on behalf of our clients, and I'm speaking as a lawyer, do the arguments that we're going to submit as a lawyer, do this arbitrator will be amenable to them, or do the arbitrator comes with 40, 50 years of a background and strong convictions about how the law should be? If I could just one final remark on how to choose an arbitrator, why not choose a legal entity as an arbitrator? When we think about arbitrators, we naturally think about natural persons, but why not think about legal entities? I'm not saying as an arbitral institution, I'm saying legal entities as arbitrators. And a colleague of mine, Professor Isabel Miranda from the University of the State of Rio de Janeiro, has very convincingly argued in her PhD thesis that legal entities can indeed be arbitrators under Brazilian law, for example. We all know that there are laws, for example, Portuguese law expressly provides that an arbitrator must be a natural person. But Article 13 of the Brazilian Arbitration Act, and so argues Professor Miranda, only requires an arbitrator to be a person of legal capacity. Well, if a legal entity can build bridges, if a legal entity can operate oil rigs, if a legal entity can be an expert in litigation and arbitration, why not choosing a legal entity to be also an arbitrator? So I think that's the last provocation, if I may say that, I would say when choosing an arbitrator, why not a legal entity as an arbitrator, as has been suggested by Professor Miranda?
Very well, very well. Let me just take a few steps back and just to share with you, Daniel and Gloria, for example, the dilemmas that I have when I'm in the process of selecting an arbitrator for an oil and gas dispute. I normally tend, because oil and gas is a very international industry, it tends to have very standards that are applied everywhere. My initial reaction is that I tend to give more importance to the international nature of the dispute rather than the specifically applicable law, for example. So, normally for me, specialization and international experience tend to be more important than the knowledge of the specific applicable law that the parties have chosen, okay? But at the same time, most of the disputes, I mean, in many cases, they have a very clear connection with a specific jurisdiction, because that's where the platforms were, that's where the exploration took place, because, you know, parties are discussing royalties relating to so it's very important also to have a very clear connection with the place, with one place that is relevant for that dispute. So the point here is how do we strike a balance between that? How to get someone with international experience and at the same time that is sensible to the local situation. And for example, in investment arbitrations, that remains very clear because the state is one of the parties. So therefore, connection with a specific state becomes very, very clear. So in you guys' experience, how, I mean, do you place more importance to one aspect or to the other? Do you try to find a balance, or it's literally on a case-by-case basis? Gloria.
I just want to say something that actually, I don't know if you noticed, but it's a connection between what Daniel said and you just say, Gustavo, which maybe comes from being a practitioner. There is some certain element of wanting to have somebody who understands very well the specific applicable law, but at the same time, there are other layers that take priority. You want somebody with an open mind. And I really like that from both of your interventions because, and that has literally happens to me quite a lot, that I see that everything happens in a specific country, but then you have a very experienced president of the tribunal on that specific law. And it's what Daniel was saying. Sometimes, I don't know if it's scary. I don't know if you are constraining already, prejudging the dispute, but by having somebody with so much know-how built upon a specific sector, that person already knows the cases. You know, you don't need to educate that arbitrator. You don't need even to give the narrative to the arbitrator because perhaps the arbitrator already knows it by heart or reads it every day in their, summary briefs. So it's not that you are prejudging the case, but you have an arbitrator that maybe has already very close conclusions of how the dispute is going to end up. And that is maybe the reason it is like all of us in this conversation to have that's what I say earlier, to have an arbitrator with two brains, one that maybe speaks more than one language, an arbitrator that maybe has more than one understanding on one formation of one legal culture, maybe, with some understanding of common law, civil law, or maybe that understands what happens in a specific context, but is also able to communicate and to relate, as you say, Gustavo, what happens in the platform, what happens with that specific type of big company. Even now with the COVID situation, the way you live COVID in Germany is not the same that you live COVID in Brazil or in Mexico, and how many, for example, of platforms literally had to stop operations, and that had a lot of problems. And maybe this is something, maybe, I don't know, just to give an example, a barrister in the UK will not understand because this did not happen. So I think maybe we're entering into a discussion where it's a lot about, and he's playing a little bit of a fortune teller. It is a lot about the psychology of the arbitrator, where is the arbitrator place. And the only way I think we can secure that is by having an arbitrator with a very open mind. And that might, and how do you assess whether if an arbitrator has an open mind? I think by the way maybe their work, some of the work they have done, a little bit more of versatile arbitrator, if I may put it that way. Rather than somebody that, as Daniel said, has worked the last 20, 30 years only on that specific type of dispute. And it is almost that you already know what your case is going to finish before you even start arguing your case. And that's not what you want. But maybe that's also a responsibility from the institutions as well, to have a more diverse roster and list of arbitrators that allows you to make that informed decision, because it's also what Daniel says, sometimes that perfect arbitrator doesn't exist. You just need an arbitrator that is independent and impartial. And as long as, the institution is giving you that, sometimes you have to compromise. I think there's also a lot of compromises in choosing an arbitrator.
Danielle?
I think the first answer is that, and it's a classic lawyer one. I think it depends on the case. That's the first answer. That's the first layer. And it truly does. And it truly does. One of the problems sometimes of arbitration nowadays is that it has maybe in some way lost flexibility and the idea that it should truly be specific to each case. But after having said that it depends on the case, I tend to think that generally you can educate an arbitrator about the law and about the case. For example, if statute of limitation is 6 years as English law, 10 years as a Brazilian law, and all the controversies that may surround the issue, I think that you can educate an arbitrator that is interested. So, but sometimes it's very difficult and almost impossible to change the culture that an arbitration brings with themselves. So I tend to agree with you, Gustavo, that sometimes we should first analyze whether we have an international or a very domestic case, and what is the mindset that we would like from an arbitrator. Because as I said, sometimes it's easier to convince an arbitrator and to tell an arbitrator how the law is, at least how you see the law as being, than teaching an arbitrator whether or not full discovery or pre-trial discovery should be allowed. So I tend to think that in some cases might be more important to choose an arbitrator based on what we could say anthropological elements than really legal elements, because at the end of the day, if the arbitrator is intelligent and amenable to your case, you will be able to teach she or he about the case.
You see, my point here is, let me give you an example. For example, in oil and gas disputes, if, for example, if the core of the dispute relates to the interpretation of a JOA, for example, which is, as we know, is a contract drafted by the AIPN. So it's a contract that is applied for thousands and thousands of projects worldwide. So when I'm selecting the arbitrator, for me, it tends to be more important to have someone who knows that type of agreement well and has experience in deciding disputes of that agreement, rather than the specifically applicable law that the parties chose in that specific agreement. So, I mean, there's some criticisms that for example, some of the models are more common law than the civil law. I don't think that, I don't agree. I think those type of agreements they stroke a balance, which I think it's fair. But but my preference tends to be more to the knowledge of that international contract, of that international practice, rather than the specific knowledge of an applicable law. Unless, of course, you come to the conclusion that the applicable law, some specific issue of Brazilian law, Mexican law, English law will be more relevant than the practice, but normally it isn't. So that's the dilemma that I face, and I imagine a lot of people face as well. Another point in choosing arbitrators here, which is does, for example, previous decisions, previous understanding of a specific issue, does it play a role? For example, if you know that an arbitrator already has a position, a specific issue, is that relevant in deciding the arbitrator for the case? Let's start now with Gloria.
I actually have a question for you, Gustavo, because when you were talking, I thought about something, and it's a genuine question from an academic to a practitioner. What if, for example, you think about the international arbitrator and you think, well, okay, applicable law is relevant, but I would rather have somebody with an international mindset. But what if, for example, the issue at the stake in the dispute is something really technical, according to English law, like force majeure or frustration or repudiation? I don't want to use the word scare, but how much you have to contemplate the fact that you must have a president of the tribunal that understands really well the law, because you don't want that arbitration award hits the English courts. So how do you make that strategic decision, or then saying, well, okay, I need this person, but also I need to be very careful that he or she understands very well force majeure under, the new developments according to English courts, because otherwise, let's say if I have a Mexican arbitrator to apply in English law, this is going to hit, this award is not going to go that far. So it's a curious question that I have. I don't know how scared you are or how risk adverse you are on that.
I think it's a fantastic question, and let me tell you how I deal with that, okay? First, it's a couple of assumptions. First, I think because we are each day more connected, everyone, I think the differences are not that great. I think the systems are more similar than they are different. Second is, I think in practical terms, I think it's easier to explain for a Brazilian lawyer to a German or Italian the concept of frustration. It's easier to plead that in the case and demonstrate how that law is applied with the expert, with the lawyers, than it is to give experience to an arbitrator about something that he or she never had. So like to explain how the industry operates, this part of what Daniel mentioned, that there's no ideal arbitrator, that has the right experience, the full knowledge of all the points that will be raised. So if I have to sort of make an effort in terms of the case, I prefer to spend time explaining how the law would be applied, how would you apply English law to a Mexican or Brazilian judge, arbitrator, rather than having to explain, how the industry operates, how the accounting principles of a JOA has to be applied. And so I think your point is very good. You need to decide at the specific situation. But again, in terms of my list of preferences, I would still put, the experience with the industry in a higher position than the specific applicable law. Because I think, at least in my experience, the good arbitrators, you can plead them, different types of law, and they'll find the right procedure for that law to be a plead and to be demonstrator. Experts will be there to explain the differences. I don't think that it's a difficult, and I think actually that's the beauty of the international arbitration. Now that's how you can. I think it's one of the ways that you have to find real neutrality, because if you always have arbitrators that are familiar with that law, sometimes they bring their own. They may bring some sort of a bias in the application of the law. I mean, at least that's in my personal experience.
No, thank you. I learned something new right now. Thank you. Thank you very much.
I don't know. We also, we have here Peter and Marilda, and then please, Peter and Marilda, feel free also to, to jump in if you want to have any comments. Now we are here on a full debate. So now I think it would be a good time to move to our last topic, which is choosing the arbitral institution. For example, in Brazil, specifically the Brazilian case, I think it's a very interesting one, because Brazil has been for the past, 5, 8, 10 years, top 5 with the ICC in terms of user. And at the same time, institutions like CCBC have been growing tremendously. Brazilian institutions are literally international institutions that, can handle cases of any type and with a great efficiency. So, and this has come to the oil and gas industry as well. Now we do see something that we would never see in the past, but we do see Brazilian institutions, especially the CCBC, as the preferred institution for some oil and gas disputes. I think this is a trend that has started and is going to continue, given the rapid success that those institutions have had. So, Daniel and Gloria, what are the criteria that we need to take into account when choosing the arbitral institutions for an oil and gas? Is anything specific, anything more important than in any other case that you would take into account? Daniel, you can start.
I think there are a few things that we should, or at least we could look for. And they're not exhaustive, but I think that those are four very they're useful guiding principles, if I may say so. First of all is permanency. You should at least try to, because oil and gas projects are major projects and normally long-term projects where disputes may arise many years after the contract has been drafted and the arbitral institution has been chosen. So ideally, one should try to choose an institution that has some sort of permanency, because it might be, what would happen if the arbitration agreement has provided for an arbitral institution that has become defunct after, when the dispute arises. So that's the first thing. That's certainly not a problem for CAM-CCBC that is really well established and will live for 200 years based on its current success. But we all know that not every arbitral institution is that successful, and we might even think about merging of arbitral institutions. So what would happen if an arbitral institution becomes defunct? So that's the first thing. The second thing that we might look is to the rules of arbitration, because when you choose an arbitral institution, you usually choose rules of arbitration as well. So I think we should look to the rules of arbitration and look if it's if modern, or if it addresses all the concerns that the parties might have, because we all know that the rules of arbitrations, once the chamber has been chosen, they incorporate into the contract as contractual clauses, so, and become binding to the parties. So the rules. The third thing that I think one should look is for specialized staff. Specialized staff makes things easier, not only for the parties, but also for the arbitral tribunal. And a specialized staff will have already dealt with so many different and complex situations that I think that the arbitral institution might, in some cases, work as an advisor to the parties and to the arbitral tribunal, and maybe share with them experiences, what has worked and what has not worked in the past. So specialized staff. And the third of all is the fees. If it's reasonably, if the work is reasonably charged. Arbitral institutions are not charity work. They don't do it for charity, and they charge for it, and rightly so. I think that good arbitral institutions provide an invaluable service to the parties and to the arbitrators, and I think that they deserved to be well paid for that work. The thing is that arbitral institutions are in the market, and so they compete with each other. And so I think that this should not be the first criteria, but I think that the scale of the fees that it's charged and how it is charged, and if they are reasonable, I think that this could also be an element helping parties choose, not the first one for sure, but one of the elements that the parties could look for when choosing an arbitral institution.
Gloria?
No, I think permanency is something very important that Daniel highlighted, and something, Gustavo, you also say, is that it has been a nice development to see how in Latin America, particularly, maybe Africa a little bit is following a similar trend. We have created very competent and sophisticated regional arbitration institutions that are catering for that service. And they are very strong, very consolidated. And you can see that with CAM-CCBC, it's a very healthy institution. And it is almost natural that they also now, as a magnet, try to attract a specific industry. In my experience, when I was a case manager in an arbitration institution in Mexico, it was a trend. I don't know how is it now, but it was a trend that arbitration institutions will absorb most of the franchise disputes. And that's the way they build up a reputation. So it's nice to see how regional institutions can keep that market, which then again goes back to understanding the culture, the political issues in there. And I think they will they will provide a better service, perhaps even better than some of the famous international institutions. I think something maybe food for thought for this committee. It is also something you mentioned, Gustavo, in terms of, okay, now that we are thinking about how to choose institutions, an issue of, for example, virtual hearings. I think there is a nice feedback about how maybe some costs have been reduced or could be reduced from, in terms of hearings, in terms of traveling, and maybe you spend that money on your experts or in other more important strategic issues of the dispute, rather than have 2 weeks hearings in a fancy hotel in London. So I think rules that also are able to cater to the new developments and to the new lessons we had this year, it's actually very, very important that we see. So I think we should encourage virtual hearings, maybe in terms of oil and gas industry, good databases, good softwares that can control all the document production, sophisticated video conference software. So I think the only thing left to see is more of that, more of those guidelines, more of those good practices that, it's not only switching from one page or the other between a bad year and a good year, but generally learn how the COVID crisis particularly affected the oil and gas industry and how that eventually is being reflected in oil and gas arbitration. I was appointed last week as an expert in a case, and the only reason I am pretty busy, but one of the reasons I say, yes, let's go for it, is because it's going to be virtual. I don't need to travel to Mexico. I can be here, and I like that. And that I think has as incidental positive consequence that is broadening up access to justice and facilitate more arbitration, more business, which is only healthy for all of us in the community. So I just think maybe that's the one something else that we have to jump, maybe some food for thought in the next few months, how all the lessons that we had this year can help, can nurture more the oil and gas arbitration process. That's really my 2 cents in choosing the right institution.
Gustavo, may I
Sure,
quickly
please.
jump in? Danielle, you mentioned one criterion, which is probably very important for institution, because this is one of the things we can organize better, or which is our objective to provide to our clients, our users, specialized staff. And I can say that CAM-CCBC is organized, like the case management teams are organized in 8 groups, and these groups both have normally 2 case managers in order to guarantee that we can cope with fluctuations. Now, case managers normally enter at an early stage in the career, and they don't necessarily stay for 30 years. So whenever someone is leaving, we always have a substitute that is familiar with the cases. And we also organize them in a way that they develop experiences in certain industries. And I think that's on the operational side, probably one thing that we look very much into, and where we see from CAM-CCBC's perspective competitive advantage eventually with regard to other institutions. And this includes, of course, oil and gas.
Very well. Thank you, Peter. Thank you very much. Well, we have come to the end of our presentation here. We could stay here for another day or so talking about this, but it's 5 minutes to the next presentation. So I would like to thank Daniel and Gloria very much for their presentations here. It was outstanding. I think we're gonna have a 5 minutes break, and then we will start with our second panel, in which Peter, Maria, and Luciana will be discussing another topic here. Okay, I'd like to thank you very much for your presence, Daniel and Gloria. Thank you. Bye-bye.
So actually, I think we could hand over immediately the virtual floor to Marilda, who is helping CAM-CCBC tremendously, not only to organize this webinar, but also to build our committee. She's certainly the most experienced and most renowned Brazilian lawyer in the area of oil and gas, not only in Brazil, but worldwide. She is also a professor of the University of the State of Rio de Janeiro, UERJ, and she actually needs no introduction here in Brazil and in many other countries as well. So I quickly hand over the floor to her.
Thank you, Peter. I think we'll use this advantage of these 3 minutes so I can explain a little bit how our panel is going to work. We have maybe a different approach. I would like very much to thank the CAM-CCBC, not only because now I'm part of the arbitrators list, but also because more recently, with this idea of an oil and gas commission, we are able actually to have a greater dialogue among the players. And it's a pleasure to be co-chairing this commission with Peter. Each week, I discover something new about Peter bio. So my thanks go first to Peter, but to all the others of CAM-CCBC, our symbol, the main lady, Eleonora, and all the others. And in this group, of course, the backstage people led by Leonardo, that we thank him a lot for the organization, Ana Furtado, and all the people that are not showing in this panel. For today, we have like a shorter of course, the main purpose of this introduction is to try to introduce you to both. Many of you already know Peter, of course, but since I myself am discovering each day, like I said, each week, something new, maybe some of you know him as the Vice President of CAM-CCBC, a very smart lawyer or as an arbitrator, but not all of you know that he is a PhD both in law and economics, and also that he has a sort of an academic background that's most impressive, because he was a professor, like we call in Brazil, professor titular in Germany, before he got in love with Brazil, for our luck, and also in love with his wife, of course. So Peter is very active in publications as well. So some of them maybe he can refer that I won't mention, but very interesting recent publications that he took part in. One of them, a book organized by Gloria, which you all had the chance to see how nice and smart she is with a Mexican background. So now, my friend Luciana, that we have the pleasure to have her interrupting her work with her PhD at the University of Grenoble to share with us some of the recent developments of her studies. Luciana got her bachelor's degree in Minas Gerais, but she never stopped studying. She made many courses in other entities, not only, so she started at the Universidade Federal of Minas Gerais, but she studied at UERJ, at COPI, and also she spent twice some study research period at the University of Texas, Houston, Texas, at the center led by Professor Jacqueline Weaver. But her move for her PhD in Grenoble was great opportunity for enlarging the experience. Her teaching activities also included the international courses of IBP, the Instituto Brasileiro do Petróleo, and she also has very important publications in the field of oil and gas. But why do we bring together Luciana and Peter before our keynote speaker? So the proposal of this panel, which is going to be shorter, maybe the idea is that here the moderator won't speak very much. I was impressed with Gustavo in the previous panel, how knowledgeable were his comments. I don't have time for that because we want to keep to the time to allow our keynote speaker to have his full half an hour. But we are going to make an introduction which brings a topic for discussion, which coincidentally is one of the topics of my research. As you all know, I started with the oil and gas contracts. So I got familiar with those contracts in my professional practice, but that led me to the interest, to academic purpose of going further into the understanding of those networks that I used in the oil and gas industry. But one of the aspects that draw my attention, living in this industry for 4 decades already, maybe I'm not in the blacklist that Daniel mentioned. No, people with 40 years are not so advisable. Well, to defend from that, I say that I keep open always to what's becoming new. So one of the things is that I got awareness during those years, how the public and private domain, they are complementary. So since I have these cycles of studying, I got back to those studies more recently, and I was so lucky to be for a few months in Hamburg, in the Max Planck Institute. And there I could go a bit further in those studies of complex contracts and contractual governance. So all these authors that study those topics, they give us a larger background that raises issues that are very important in the analysis of the contracts of our oil and gas industry that we are focusing today. But I would only like to highlight very briefly that context, because actually is the topic of a regulatory private law. And so all these issues that are raised in these networks, other fields of research are pointing out the importance of those networks and supply chains, for many other relevant issues that are discussed in the industry nowadays, like accountability, liability across the chain, and even for professors of international law that are already migrating into a perspective of international law as a global law. We have the University of Sciences Po, Professor Diego Arroyo and Horácio Muivet, that study the cases that are very rich and interesting. So in those supply chains, we can go into dark spots when you only use the applicable law and jurisdiction criterion. So we want to go a bit further into understanding how the soft law, on the one hand, the lex mercatoria, and all these discussions, which in the industry are named as lex petrolia, how do they relate to the regulatory, strictly speaking, emanating from the state? So then we have proposed that Luciana will speak first, so it will be a different dynamic than the previous group. We won't have topics to go back and forth because we don't have time for this. But Luciana, with her experience as a regulator and with her further studies, which she performed recently, she'll focus on one main topic, which illustrates in a formidable, amazing way how these regulatory chains work. And after Luciana, then Peter will do a dialogue covering not only the general contractual issues that Luciana is going to analyze, but also some of the aspects of the contractual chains when they go into the financing and other necessary and complementary areas. So Luciana, I'll give the ground to you and we'll be happy to listen to your comments.
Good morning, everyone. Thanks, Marilda, for the presentation. It's a pleasure to be here. I would like to thank the CAM-CCBC as well for the opportunity to talk. And it's a great honor to share this panel with you and Peter. I'd like to say that my presentation reflects part of my research at the University Grenoble-Alpes, and also my experience as regulator at ANP, but I'm not talking on behalf of ANP. So I'll talk, my presentation, it's more about my PhD research. And I will I'll share my presentation. Just a minute. So this panel is about contemporary challenges in contractual networks in the oil and gas industry, but I will limit to talk about upstream contracts. There are many contractual networks in the oil and gas industry, but I will focus in the upstream contract and unitization agreements. So what are the upstream contracts? There are two categories. The first one is the host government contracts or international petroleum agreements, which take the form of concession agreement, production sharing contracts, and service contracts. And the second category is the private contracts signed between oil companies. And for these contracts, there are many model contracts. In the paper of Martin and Park from 2010, we have some examples of upstream agreements and other agreements. With a red arrow, I showed the ones that important for the unitization agreement. I'll talk more about them in the next slides. But what are contractual networks? And according to Marilda, in her a recent working paper on contractual complexity, contractual networks occurs when several contracts are necessary to practice the same operation. These contracts keep a finalistic link between them. And how does contractual network occur in the upstream? The contractual network in the upstream sector takes place even before the operation is carried out. In other words, before the companies acquire the exploration and production rights on a specific area. In this same working paper, Mario Del Rosado states that upstream contracts are complex and emphasize the importance of contractual models to face this complexity. And I will show some model contracts adopting the upstream contractual network. Before the bidding round, when companies would like to present a bid jointly, it's important that they align the conditions through a study and bid group agreement. And if they want to share some data, they must sign a confidentiality agreement or data exchange agreement. If they have successful bids in the bidding round, they must sign a host government contract with the host country. And if they present the bid together, they must sign a joint operating agreement to establish the terms of the joint operation. And Tim Martin will talk about this contract in the next panel. So during the operation, many other contracts it's possible, and an example of them is the farm out agreement. If any company wishes to assign a portion of or all of its participation, and the unitization agreement, the focus of this presentation. If during the exploration phase they discover a deposit that extends beyond the limit of the block, they must set the track participations, the rights and obligations in order to perform a joint development. And before to talk about unitization, it's important to say why unitization is it's a relevant issue in Brazil. Many of pre-salt fields many of them have shared reservoirs, and many of these reservoirs extend to an open area. So it's necessary that PPSA, the public Brazilian company, enter in the negotiation of the unitization agreement as well. So, in the pre-salt area, there are many fields with different kinds of contracts. We have concessional agreements, production sharing agreements, and some onerous assignment agreements. So that's why unitization is a relevant issue in Brazil. So unitization can be defined as a practice that occurs when the natural accumulation of hydrocarbons within host rocks extend beyond domestic licensed borders for exploration and production. Unitization established the joint development and production of a petroleum accumulation that straddles such a boundary, avoiding wasteful competitive drilling and weakened recovery of petroleum. Unitization, in fact, it's a compulsory association. So, and within the unitization process, we have another contractual network that starts with the confidentiality agreement or data exchange agreement, because it's a premise of unitization sharing the data. So the companies must sign a contract in order to set the terms for this share. A pre-unitization agreement is recommended when a joint reservoir appraisal must be carried out, and the unitization agreement must be signed to define track participation and other rights and obligations, and must submit it in Brazil to ANP approval. together with the unitization agreement, the unit operating agreement, a kind of JOA for the unitization, must be signed to set the terms of how the joint development will be carried out. And AIPN recently launched a single model contract for unitization and unit operating agreement. In Brazil, this is a little bit complicated, doesn't work because ANP just want to analyze specific informations. There is no capability, technical capability and resource to analyze a complex agreement as a unit operating agreement. So we set the points that is important for ANP at the ANP unitization resolution. So we got generally a most simple document. So after that, the accounting procedure must be signed to set conditions of how the expenses and profits will be shared. And in Brazil, specific for pre-salt area, there is another specific for the unitization process in pre-salt area that involves an open area, that involves PPSA. Another model contract must be signed, the equalization agreement of spending and volumes that was developed by PPSA and Petrobras. And the Olavo Bentes has written about that in the recent Congress of Rio Oil and Gas. So it's quite new, and you can find information about this new contract there. And about complexity and regulation, for dealing with unitization process complexity is necessary to have an efficient unitization regulatory system. And state and non-state actors must act together in this regulatory system, gathering diffuse expertise. And state and non-state rules must be in the same regulatory system. So it's necessary to move away from the positive logic and adopt a broader approach to regulation, considering the non-state rules validity. So as Marilda said, we have the theory of Lex Petrolia, but this theory, considering the Lex Petrolia's rules, the Lex Petrolia order as an autonomous order, completely independent from the state. And in my research, I adopt another view, the view of Halliday and Schaeffer, that these authors propose a transnational legal order. And according to this logic, you have a broader approach of regulation, of legal order. So the transnational legal order will include state rules and non-state rules. The national legal order, the international and also the international legal order will be included in this transnational legal order. I have some representations. The first one is the positivist logic with the state on the top, in the center, the constitution as the fundamental norm. And now a representation of transnational legal order, which includes all the actors that are relevant for the upstream sector and the private rules as well. And what are the relevant non-state rules for the unitization regulatory system? We have three kinds of rules, and I think we can have another one that I will talk later. So we have the good international petroleum industry practice regarding unitization. The most important industry practices are they related to the technical basis necessary to calculate the volume of hydrocarbons present in the shared deposit and consequently track participation. And according to Worthington, in his book of 2020, he points out 5 professional associations that stand out that produce these rules: the Association of Geoscientists and Engineers, the Society of Exploration Geophysicists, the Society of Petroleum Engineers, and the Society of Petrophysicists and Well Log Analysts. Also, the model contracts that Martin and Park talks a lot in the paper, and they argue that adopting this contract having the following advantage: cost efficiency, speed, risk avoidance, high quality contracts, broad industry understanding, improved relationship, association development. And we have the AIPN that stands out, producing upstream model contracts. And also in my thesis, I consider as non-state rules, regulations from other host countries, because are not producing inside the Brazilian national legal order. So regulations from US, UK, Norway, for example, and other producing countries are relevant for the unitization regulatory system in Brazil. And here we must highlight the importance of comparative law, and Marilda can speak better than me about this. An example of the importance of these rules for the Brazilian regulatory system, as an example, we can point out the ANP resolution number 25 of 2013, the unitization resolution. The rulemaking process of this resolution adopted as reference the unitization agreement model of ANP from 2006, the UK regulation on transboundary unitization, also the doctrine of host countries with more experience as US and UK, and for others, for the update of this unitization, of the unitization resolution, for the rulemaking process of CNPE unitization resolution, as well the other regulations from other producing countries were analyzed. So we can observe the influence of these non-state rules in Brazilian regulatory system. So in fact, this influence, there is not well coordinated by the state. So we receive that without indirectly, without to well analyze the other possibilities. So it's necessary to change the governance model and establish a new role for the state. And Abbott and Snidel propose that state act as orchestrators, adopting a transnational new governance model, bringing together state and non-state actors, coordinating the interaction between state and non-state rules. Brazilian Energy Minister and ANP, the public institutions responsible for the unitization rulemaking process, would orchestrate the multiplicity of state and non-state actors that are part of the unitization regulatory system, create discussion space such as forums, seminars, workshops that bring together regulators, companies, professional associations, universities to discuss joint solutions. Because for complexity issues, we must bring together the diffuse expertise and some force. So there are some final remarks. It's important to give validity to the rules developed by non-state actors within our legal system to be able to recognize the influence that these rules have on the process of elaboration, interpretation, and application of domestic rules. And it's necessary to migrate from the positive logic to take a more integrated view of the regulatory system. State resources are increasingly scarce. It is important to have the expertise and resource from private actors can offer. So, however, with a more active and critical posture in the face of the interaction of transnational rules with the national order. As Ralph Michael says, we would be experiencing a paradigm shift, which, in the terms used by Austin Kershaw in the theory of droit en réseau, requires the transcendence of the state. So that's it. Thank you. And I pass the word to Marilda. Oops.
So, Luciana, while you, yes, great.
Sorry.
So, it's fascinating how you managed to cover all these issues that are included in this works and doctrinal background of the authors you quoted. And I hope we'll have time to come back to some of the issues that you raised. But I would like, before we discuss further the richness of content of your presentation, I would hand over the floor to Peter, because then we get into a further complexity, and then we'll have some time for the discussions before we end our session and give some time to our keynote speaker. So, Peter.
Thank you, Marilda. Well, it's a great pleasure to participate in this panel with such distinguished experts of the industry, specifically the regulatory aspects. And it's a challenge also. And I was analyzing this morning, particularly, and yesterday evening already, your presentation, Luciana, and I think the bridge building element is, and this is to some extent a good coincidence, is the opinion or the position you mentioned that our keynote speaker is defending in the context of your topic, model contracts, and how these model contracts emerge, what are their limits, what are their advantages, and how different actors in the industry can influence the content of these model contracts. I will explain this against the background of a specific type of transaction which we uses or which depends to some extent on these concession agreements, but also on resources from non-commercial banks, just like the World Bank, and for instance, or the Inter-American Development Bank, BNDES in Brazil, of course, but these players, they can also set standards that influence the model contracts regarding, for instance, financial issues, but also commercializing of oil and gas. Before I will do so, I would like to, that's not the picture I wanted, actually. Yeah, I would like to start with just a very few institutional remarks. Why CAM-CCBC is launching this committee. Of course, Rodrigo in the beginning my colleague as a vice president already outlined our objectives, but I would like also to put the idea of the committee in another framework. It's part of our internationalization strategy as well. We are in Brazil, the marking leader, but of course our objective is to expand beyond national borders. And I think we have made our homeworks. We are prepared for that. CAM-CCB's case managers are capable to administrate cases in English, Spanish, and Portuguese. We can also support hearings offshore, which means not in Brazil, hence in the US, for instance, Canada, London, or Paris, wherever it fits to the needs of the industry. And thereby, and this relates to the topic or the discussion, particularly between Gustavo, Gloria, and Danielle, we can provide services for domestic and foreign awards, which is the most important distinction in our arbitration law. And this comes in an important point. And this has to do with the approach of our Superior Court of Justice when in exequatur proceedings. As Gloria mentioned, different jurisdictions, different courts apply sometimes different levels of due process requirements. For instance, when it comes to grant exequatur for national or international awards. It was mentioned that France and Switzerland, for instance, hardly, French or Swiss courts hardly ever interfere into or deny, let's say, exequatur due to due process or other ordre public issues. This is slightly different in Brazil, I would say. The STJ criteria are not so different between annulment of national awards and requirements with regard to due process when asked to grant exequatur for a foreign award. Therefore, I think due to our expertise regarding due process requirements established by the Brazilian Superior Court of Justice, we have a competitive advantage regarding other institutions when it comes to guarantee that foreign awards will pass exequatur proceedings smoothly in Brazil. This also relates to something that was mentioned previously by Danielle regarding the criteria to choose arbitration institutions, specialized case management teams, and a communication between these teams and arbitrators and arbitral tribunals. And I think that's an important issue whenever there's a high probability that an award which refers to the oil and gas industry needs to be executed in Brazil. Then actually, I think this is always a concern by parties. And last but not least, due to the traditional high relevance of the oil and gas industry for the Brazilian economy as a whole, CAM-CCBC holds a solid track record of cases related to that industry. We have in our arbitrators roster experts like Marilda, but also international arbitrators. And the roster is also not binding. It's recommendable regarding the president of the arbitral tribunal, but it's an open roster. So that said, I would like now move on to this picture. What is this? Well, this is an electric power plant. It's a specific electric power plant because it's fired by natural gas. So I would like to combine, and this is another, let's say, another challenge or another aim we have. We would like to include in our oil and gas committee also broader aspects of energy law. So I will talk basically about project finance structures as contractual networks, and an example where we have a high standardization of contracts, although always tailor-made to the specific characteristics of a project. We have, and this picture seems to be quite complicated, but actually the project finance network in practice is even much more complicated. But we have here several players, and we have a dependency of the various different contracts that are used here. And this is important, in my opinion, when it comes particularly to contractual issue that is in Brazil or subject to Brazilian law still a little bit more controversial than in other jurisdictions. So let me start by explaining the function of some of these players. Normally, when we are dealing with oil and gas or energy industry, in order to start operations, we need some kind of concession granted by the state or state authority. And obviously, when publishing the call for tender in Brazil, the edital, the regulator or the government can already set the parameters for the whole contractual structure. And this obviously challenges or limits also the contractual freedoms, because in order to get to make a successful bid, the whole structure needs to be adapted to the call for tender. On the other side, in the of the picture, we have public banks. That's what I mentioned before: World Bank, regional development banks, foreign export credit agencies involved. These players are important to stabilize the financial structure of the project, because typically only they are capable to lend money long-term for a fixed interest rate, because they have a different refinancing structure. They are financed by the treasury of the state or by an international organization. They do not have to refinance them on the capital market. This is different with regard to the commercial banks. They depend on the international financial market to refinance long-term lending shorter, especially in the energy sector. And I think Daniel mentioned this before, we have a long-term amortization period, 15 years in mining business, where this structure is also quite frequently used, 30 years, 50 years. So it's a challenge for banks, for commercial banks, to provide finance for these huge capital intensive projects. And this also brings me to another driver of standardization of, or the use of, or the emergence of rather standardized or model contracts. We are talking here about projects that have a minimum investment of some $100 up to billions of US. And therefore, it's clear from the outset that the commercial banks that lend up to 70%, 60% of the overall financial resources needed to establish such a power plant, or to establish a mine, or to establish exploration production platforms in the oil and gas business, that this will not be a single or a small group of banks, but rather a banking consortium. And in order to get many banks involved and to facilitate the process of building a consortium and eventually later on a securitization, the loan agreement must be somehow standardized. On the top, we have a sponsor and co-sponsor with a joint venture agreement or joint operation agreement where the other aspect may come in, and they inject equity capital or subordinated risky debt capital in order to finance the project. Then we have on the left side of the slide, we have a lot of yellow arrows. Why so? Well, the color yellow stands for the money and the direction of the flow of money. So eventually the government will receive royalties in order to produce, I said it's a natural gas fired power plant, our example. So we need natural gas, and the natural gas producer will, of course, sell the gas for money. So the money will flow out of the project to the gas producer. EPC contractor is the engineering, procurement and construction company that sets up the facility of our power plant. Then there are certain risks that can be covered by insurances. So insurance companies will also always be involved. And then we need additional service provider, for example, water and wastewater. In the middle, the centerpiece where our contractual network is attached is the project company, owned by the sponsor and the co-sponsor if there's one. And these companies are special purpose vehicles subject to local law in general. So if the project is located in Brazil, the company will be set up subject to the Brazilian law for limited liability companies or for stock corporations. And now I focus on where I see eventually a difference or let's say a challenge to some extent regarding the standardization of these type of structures for energy project is on the offtake side. Of course, in order to predict the capacity of the future capacity of the project company to pay royalties, to make all these payments, also to repay, obviously, principal granted under the loan agreements and pay interest depends on how good the company can sell its product, in our case, electric energy. So in order to make this predictable, the company, the project company will enter into a long-term energy sales and supply agreement with an electric energy distributor. The duration of these agreements will be tailored to the duration of the concession agreement and also to the duration of the term loan and the fixed rate term loan or guarantee granted by public banks. An essential element of the agreement between the project company and the off-taker, the electric energy distributor, are take or pay clauses. Well, what does this mean? Take or pay clauses define typically a minimum quantity of electric energy that the off-taker should acquire, and the contract will also define a price formula. This is extremely important in order to enable the banks to make a cash flow projection of the project. We must understand that when these projects, these energy projects are financed, we have just a certain amount of paper, but we don't have a real asset yet, because it's something that is going to be built. It's not like M&A business where you acquire a company based on the financial numbers, typically of the last 3 years, with an adaptation clause. Here you really depend on the analysis of the contractual network that is so far just hundreds of papers. And if you compare the contracts that are responsible for the outflow of money with the contract, the offtake agreement that is responsible for the inflow of money into the project company, you can make such a cash flow analysis, and you can especially calculate 2 ratios that are typically used in this industry or in these projects, also used in leveraged buyout finance to some extent. And this is the debt service cover ratio and the loan life cover ratio. The debt service cover ratio sets the net operating income, which means that you have to compare costs or expenses and inflowing money in ratio to the debt service interest plus principal payable in certain moments of the contractual relationship. Depending on the risk level, the market requires 1.15, 1.35 minimum in order that banks may jump in and not shy away from the financing of a project. The second ratio is the loan life cover ratio, which sets the net present value of the cash flow available for debt service in ratio to the outstanding debt in a certain period. Said ratio in infrastructure or energy project, and depending on the risk level and on the region, must be somewhere between 1.5 and 2.5 in riskier projects, at least. Why I'm telling this? Because I want to sensibilize you for the relevance of offtake agreements, and particularly for the qualification of these take or pay clauses. As I said before, they are tailored to the duration of the loan and concession agreement. There is a predetermined quantity that the off-taker needs to acquire in certain periods. The quantity does not need to be identical in all periods, and the off-take price is calculated according to the predetermined price formula in the contract. What is the objective of these clauses within the whole setting of our structure? Well, it is the mitigation and allocation of the market risk for electric energy, the output of the project, in order to make the cash inflow into the project company predictable, and thereby enable banks to provide financing. When we qualify now from a legal perspective these contracts, I think it's very important to understand the economic logic of these clauses or these contracts as a whole. Well, I was always very poor in painting. In school I was terrible, and this picture is certainly not very nice. My kids will probably smile on me, but I think I could make it understandable. The red line shows the development of the price for electric energy in the spot market, which is the market for 1 day, purchase and delivery. And as you can see, the red line is oscillating, while the black line is a rather linear line. And this is the objective of the take or pay clauses in offtake agreements for electric energy. And as you can see, the delta between the price defined in the take or pay contract, and on the other side, the price of the spot market is typically, the delta is typically in favor of the off-taker. And this is absolutely logical, because someone who commits himself to acquire a certain quantity of energy over a period of 15 years or more will only do so if in average the price he needs to pay is below market price. But this, of course, does not mean that in some periods of time the red line will be below the black line. And this is where I tried to make some pink paintings. Yeah. But if you compare the pink and the blue, you will see that blue is bigger than pink. But obviously, in some moments of time when we are in the pink phase, the off-taker might, because he has eventually financial problems, or because he has the opportunity to acquire its energy from another provider, he might behave opportunistically and challenge the validity of the clause, saying that under Brazilian law, for instance, this is not an ordinary price formula, a binding price formula, it's a contractual penalty. Well, if a judge, if an arbitral tribunal comes to the conclusion that is really a penalty in the terms of the Brazilian Civil Code, Article 413, this means that the arbitrator or the judge can adapt the price to the current market price, let's say, which of course will cause a distortion in the whole long-term setting. And knowing that this might happen will cause that providers, banks, particularly commercial banks, may shy away from that. I personally would consider eventually such a clause rather than an element of risk allocation, which is also the international most common perspective. And since this year, we have in our civil code a new article 421A, which in resume states that risk allocation provided explicitly for in contracts, particularly between commercial parties, not talking about consumer law. These are highly professional commercial agents here, should be respected by courts and consequently also by arbitral tribunals. Of course, there may be an external shock which hits the energy market as a whole and not just one single contractual relationship. In these cases, obviously, we can raise the question differently using different institutions of contract law, such as the contractual basis, the economic contractual basis, or a base jurídica do negócio, in português, para eventually adapt the contracts. But in general, this is probably not what parties had in mind initially when they signed the contract. As I said, this doesn't prevent anybody from later on behaving opportunistically or trying to use whatever rights are provided for in common law, in civil law, to walk away from a contract that has become less beneficial. I mentioned here an English law precedent, and that is pretty much interesting for everybody who's interested in this topic. Just to come once again quickly back, and then I'm already finishing to the contractual network. It's very important to know that the credit agreement, the secure term loan, will include so-called cross-default clauses. What does this mean? Because the whole financial situation depends on the smooth functioning of all the other contracts, concession agreement, the supply of natural gas, and of course the offtake agreement, because if there's no offtaker, the project company will have no other source of income to pay interest and repay principal. So every default under one of the project contracts will be classified in the covenants of the long-term financial contract as a cross default. So whenever some disruption occurs under the offtake agreement, it will automatically cause a default under the loan agreement, which enables the banks to renegotiate, to be immediately part of the on the renegotiation table. And therefore the risk or whatever, whenever tribunals decide on one of these contracts, they should be aware that these contracts are part of a contractual network, and that any decision in a single contract might destabilize the whole structure. This brings me to my last remark. Of course, the dream solution here would also be, now coming to arbitration, an umbrella arbitration clause. Because as you can easily imagine, in this setting, the risk of multi-party arbitration is huge. And consolidation of arbitrary proceedings and coordination would improve efficiency of proceedings a lot. But in order to do so, we would need to have same arbitration law rules applicable, same institutional rules, and so on. That said, I give the floor back to Marilda, and I thank you for your attention.
Thank you very much, Peter. Unfortunately, like Gustavo mentioned in his panel, we could be here forever, but we only have 4 minutes left, and I don't want to steal any minute from our keynote speaker, which we are eager to hear about his experience. But I would like at least to address 1 or 2 questions for your brief comments. And I would first come back to one of the many interest comments that Luciana made when she mentioned the importance in her acknowledgement, although she doesn't speak about the position of the agency. Of course, she made a very clear disclaimer, but at least as an academic and as someone who studies unitization, you mentioned the importance of the discussion spaces. And I wonder if what you had in mind and which examples you could mention to us about effective and real chances that you had to access those discussion spaces.
Thanks, Marilda, for the question. We have, for the offshore safety, we have the International Regulatory Forum. It's a space that brings together the regulators, companies, service companies that are dealing with offshore operations, so, and non-governmental organizations. So I think we need, I don't know if similar space with specific object or more broad object, but spaces that the multiplicity of actors can talk together and discuss these complex issues.
Well, of course, that's very interesting, because when you mentioned the unitization, you were quite clear about the research that you're performing and the importance of the good practices of the industry, how the Brazilian model of concession contract right from the start sort of adopted. In that, in the technical side, it has, you made a specific reference to technical entities. But of course, it's my role to remind everybody about the importance of the Association of International Petroleum Negotiators. During many years, I benefited from the discussions of a model contract workshop, and recently also the discussions about unitization each year. I don't know if we're going to go into virtually, and I'm still a member of the Educational Advisory Board. Well, so at least one question to Peter. You made an incredible presentation showing just backstage complexity that goes around the oil and gas industry. So talking about oil and gas industry is not only the specific networks of contracts, and we'll have the chance to listen from Tim comments about problems that arise in the core, which is the most energetic document, which is the Joint Operating Agreement. But I was interested to ask you, with your comparative law background, Peter, which were the main challenges that you faced in Brazil when you adapted? Because I myself had the experience of the project finance of the 90s, and then still in 2000 and something, but not an updated in features of this, what's happening today in the same proportion as I had as an in-house lawyer. So, for instance, concerning the choice of foreign law or whatever you faced as a challenging aspect when you entered into the Brazilian adaptation of a project finance international experience.
Well, that's a very good question. Two things maybe. You mentioned choice of law. Very brief answer on that. And this is different from many other jurisdictions. Brazil used to have a very liberal private international law, especially when it came to choice of law clause in contracts. That was established in 1916 in conjunction with the first Brazilian Civil Code. Unfortunately, during the period of Estado Novo in 1942, when the current private international law of Brazil was adopted, Article 9 reduced this freedom to choose foreign law. If the characteristic obligation needs to be fulfilled in Brazil, which is in the case of energy delivery contracts or supply contracts, of course, the case, then it's difficult to negotiate the application of a foreign law. It was then it changed in 1960 with the arbitration law, because Article 2, paragraph 1 provides for that parties can choose the applicable law, and this is interpreted not only with regard to the choice of the arbitration law, but also to the choice of substantive law. So if you have an arbitration clause, if a contract is subject to arbitration in the future, then you have more freedom to choose the law. This is one thing. And if you ask me in general, what is a challenge to foreign lawyers when confronted with Brazilian contract law, particularly to English lawyers, and this reminds me of Gloria, it's of course that particularly since the Code of 2002, Brazilian contract law establishes a number of instruments that enable judges and arbitrators to rewrite the contract to some extent. We have a social, subject to Brazilian law contracts have a social function, which is for an English lawyer certainly bizarre. I don't want to criticize this. I just say it from an international perspective, social function of commercial contracts is a unique thing of Brazilian law. We have the economic, financial equilibrium clause, which is not common to in that way to English law, and we have, of course, the good faith principle, which is applied, for instance, when compared to a jurisdiction, my original jurisdiction, German law, which is said to be a jurisdiction favorable to good faith. That's certainly right from an English perspective, but Brazilian contract lawyers are far ahead, let's say, regarding the scope of application of good faith when compared to German lawyers. And I think that's pretty much the difference when we talk about contract law.
Okay, I would like to thank very much both panelists, mostly like Luciana, and allow her if she wants to drop to the backstage, because I can tell everybody she also has a baby to take care of. So I have to thank her very much, not only to interrupt the thesis research, but also Martin, send my kisses to him. But ask Peter to bear with me. Maybe we can host Tim Martin together. So I would very much like to welcome Tim Martin. I know he's standing by us already. I can see his picture, but let's see him alive. Hi, Tim. Welcome to Rio in a virtual mode. We are very happy to have you with us today. And people asked me to make a brief introduction. You don't need a moderator. You're our keynote speaker today. But you know, I just have to tell my colleagues of the commission that I'm so proud that Tim accepted our invitation, because, you know, I am at that stage that I have to mention. It's not in every corner that I meet the people who, like me, have 40 years of experience. But the problem is that Tim, in his 40 years, he did the dark side of the quarantine. We have a good opportunity of having the international speakers and the friends coming virtually to Rio. But of course, we cannot have a beer together. So because of the time constraints, I won't be able to pose questions today, but I'm sure this opening and your participation today will be the first of many ideas that we can share. And as you know, I told you, I cannot be in the day-to-day with the journal, but we can have ideas of cooperation going further. So I would like to thank you once more and all the speakers, and give the floor back to Peter to say the final words on behalf of CCBC, because he's in our panel, but he's also the vice president of CCBC. Peter.
Yeah, thank you, Marilda. It's a great pleasure to share with you this launch of our committee. And I will be very brief. Thank you very much, Tim, for giving us the honor to have you in this launch. Particularly interesting for us because, as you might have remarked, we have some link originally to Canada, because we are a child of the Brazilian-Canadian Chamber of Commerce, nowadays much bigger than the mother, or actually, and not limited to Canada. But of course, we always try to establish some links to between Canada and Brazil, and therefore we are very happy to have you here today, virtually, hopefully next year physically. And I think the relation Sao Paulo, Rio, Calgary is certainly one important link for us. Although I would like to mention, the intention is to be very international. We had participants from Switzerland, Portugal, the UK, Mexico, of course, and Brazil and many other countries. So I'm really happy that it worked. And now I would like to thank everybody for the patience, particularly our audience. And we will definitely continue our work, and probably after now is coming the summer holiday and Christmas period in Brazil. And I think we will be back with some events after Carnival in late February or the latest in the beginning of March. Thank you so much, and have a good day. Have a nice weekend, everybody. Bye.
Obrigado.
Obrigada.
Obrigado.